part-time employer in the matter of the application of National Council for Civil Liberties and Secretary of State for Underhill.
My Lords, I'm going to be about 2 minutes. I just wanted to perhaps answer the mystery that was posed yesterday by the handing up of Section 119A of the Building Safety Act. We've discussed timings amongst ourselves. I'm going to be hopefully about 2 minutes. Then my learned friend Ms Higgins will be between 1.5 hours and 2 hours. That should leave time for Mr de la Mare to have 15 minutes, and then Sir James to reply. And so my Lord will recall that the way in which I structured my submissions yesterday, to start by asking what these regulations did, then to address it by way of simple statutory construction, and then third to address it as a Henry VIII power. This provision, which we've handed up, is of particular relevance to the second and third stages. I'm going to do them in the backwards order. So from a Henry VIII perspective, our power that we're looking at in this appeal is a Henry VIII power, and there are particular constitutional reasons for giving a restrictive interpretation. The question is not whether the power is sufficiently broad to incorporate what the regulations did. It is only where there is no doubt at all about what the statutory provisions mean that the restrictive approach advocated in PLP doesn't apply. Secondly, the second stage, of course, was as a question of parliamentary intention and construction. What did Parliament intend? And my Lord knows our submission on this, which is that it's far less likely that Parliament would have used this power to expand the substantive scope of a criminal offence in the context of civil liberties. And we say that follows from the language itself, from the statutory context, from the context of the provision and the purpose of the powers. And this provision explains both of those points, because my Lord will see that Section 119A(10) of the Building Safety Act is a provision which is about making provision about the meaning. And so your Lordship, the Vice President, asked yesterday whether Parliament had used that type of expression in other contexts. Whether Parliament had made Henry VIII powers that were about the meaning, if I can use that language. Yeah. And so here we have Parliament doing exactly that at Section 119A(10). And the way in which Parliament did it in the Building Safety Act is the Secretary of State may, by regulations, make provision about the meaning of connected replacement lease, and then in brackets, including provision changing the meaning. And so that is an example of a Henry VIII power where there is no doubt, because Parliament is expressly permitting the Secretary of State to change the meaning. And it is also an example using simple principles of statutory construction of a statutory provision where Parliament expressly and clearly intended the Henry VIII part to be used to change a meaning. And so for those two reasons, that statutory provision explains why our proposition must be correct. Because if the words making provision about the meaning was sufficient to enable the Secretary of State to change a meaning, then it would have been otiose for Parliament on this occasion to include the parentheses, including provision changing the meaning. And so that's why we say, as a matter of natural and ordinary language, this appeal should succeed. For those reasons, can I pass on to Ms Higgins?
Thank you very much.
My Lords, I'll address you on Appeal Ground 2, which is the consultation ground, and the structure of my submissions will match those of Sir James, so I'll begin with some brief observations on the facts. Secondly, I'll then address you on the characterisation of those facts, i.e. are we into voluntary consultation or something falling short of that? I think your Lordships have the point that our case is not that this was a case in which there was a freestanding duty to consult. We put our case squarely within the realms of what I'll call the Cochrane principle, that is, the government chose to consult, and having chosen to consult, they had to consult fairly, and then fairness extended to who they chose to consult. Thirdly, I'll address standard of review. Is it fairness or is it rationality? And then finally, Section 4, what does fairness alternatively rationality demand on the facts of this case. So turning to the facts, Sir James obviously showed you the underlying documents. What I'm going to do is just bring out a few points by way of emphasis, if I may. Firstly, I have 3 points on the 1st of December roundtable meeting. And it might be helpful if your lordships could just take up the Divisional Court's findings on that meeting, which are in Core Bundle, tab 5, page 66. And this is paragraphs 133 and 134 of the judgment. So 3 points on the roundtable meeting. The first point is that one can see from these findings that the regulations ultimately came out of a proposal put forward by the NPCC, the National Police Chiefs Council. And I make that point because one of the matters that the Divisional Court ultimately relies on at the end of its analysis on what fairness required was this idea that the government couldn't reasonably believe the exercise it had carried out with these sorts of organisation was balanced. And so I just make the point that the police bodies were the source of this proposal.
The source of the proposal that it should be more than minor?
No, in a more general sense.
Oh, right.
So in a more
source
general
of the
sense, their
requirement
proposal
to get specificity.
as to serious disruption, yes, and they make a suggestion about being able to take account of cumulative disruption.
Sorry.
Second point on the roundtable meeting is that this proposal from the police bodies is a reaction to a request made by the Home Secretary at the outset of the meeting for solutions to what she saw as the problem of disruptive protest. And I emphasise that point just to set up what might be quite obvious, namely that the intended purpose and effect of these regulations was that they would be used in practice by the police to impose greater conditions on what would otherwise be lawful protest activity. And I make that point at the outset because one of the points that Sir James came to when looking at the reasons on fairness was the reliance on the economic note, and he made a point that effectively it's all an estimate. And in my submission, what the economic note did was effectively breathe a bit of empirical life into a point that everyone knew from day one, which was that the Home Secretary was going to make these regulations only if she thought that they were actually going to be useful in practice.
Sorry, at this stage?
At this
It's not
stage,
the
yes.
regulations, is it?
Well, that was my third point, my lord.
Sorry,
My
that was fine.
You've anticipated my point, but my...
The second point, obviously I understand what you're saying. But just tell me again, why is this a point of significance for the consultation question?
We say that will go to fairness. And so one of the reasons that the Divisional Court placed emphasis on when coming to assess what fairness required was this idea that the regulations would lead to greater exposure to criminal sanction and also interference with fundamental rights. And they look at the economic note, and the point here is simply that one could ignore the economic note entirely, and I would be able to say to you, look at the minutes of the roundtable meeting, it's patently clear the Home Secretary is thinking about making this sort of legislation because she wants to crack down on disruptive protest. In other words, the intended purpose and effect is that these powers will be used in practice.
Isn't that too obvious? Has James said anything different?
Perhaps not, but I wanted to just make sure that from the
fine. I just want
get-go,
to see what it's saying.
that point is clear.
Yeah.
And then the third point is that what comes out of the roundtable, and we see this at the very end of paragraph 134, is that the ask from the Prime Minister is that the Home Department looks into getting a statutory instrument before Parliament before Christmas. So the proposal starts life as secondary legislation. Now, I totally accept, of course, that by the time that we're sort of in mid-December and we've got those draft clauses being commented upon by the police bodies, they're all referencing the Public Order Bill. And so Mark Williams, his witness statement is to the effect that the proposal became to pursue primary legislation. But his evidence is also that even whilst they're preparing amendments to the bill, in his words, secondary legislation was, quote, left on the table. And that's Mark Williams, paragraph 16, Supplemental Appeal Bundle, tab 13, page 110.
paragraph,
It's paragraph 16
thank you.
of Mark Williams. So that's the roundtable meeting. If I may then just make some points on the sharing of the draft legislation on the 15th and the comments which come back on the 21st of December. And one refrain in Sir James's submissions was to say, well, of course, the sorts of issues that the government was discussing with the police bodies were all terribly narrow and they were all concerned with sort of operational implementation. But in my submission, the Divisional Court rightly rejected that characterisation of events. Instead, it held in paragraph 183, Roman numeral 5 of its judgment, that the matters on which the government engaged with the enforcement agencies included the most important aspects of the proposed measure, including legal, practical, procedural, drafting and human rights implications. And I think it's worth just spending a little bit of time on that response document just to understand why the Divisional Court reached that view. And so if I could take you please into Supplemental Appeal Bundle, it's tab 23, page 148. And so this is the joint response, and one can see we've got the questions posed in black, and then the response is in green.
So you said 148, or do you mean 146?
So the cover email starts at 146, but I'm going to jump ahead and just look at the body of the
That's why it's
responses.
The attachment.
The attachment at
So that's
148.
24.
Apologies, 24, you're right. And the submission I want to make on these questions and responses is that there's a difference between the first 6 and what is the penultimate number 7. Questions 1 through 6.
Sorry, now I've got, we're in tab 24.
Tab 24, page 148.
Which are questions 1 through 6.
We lose the numbering of the questions, but
Sorry?
we lose the numbering of the questions in this document, so I will take you through them and just explain what I mean.
So what we have to go back to, I see.
So the first block of text in black is question 1.
Yes, I see.
And that,
We'll give it a second.
yes.
1, 2. That should be 8.
Yes, it goes to 8, but 7 is the one I'm singling out as sort of different from the rest.
And now I understand what you're saying. What we're saying, what's the difference between 1 to 6 on the one hand and 7 on the other?
Well, let's start with 7.
Yeah.
7 is asking about the way in which they've defined the term senior police officer, and they're saying, is this an appropriate reference? Now, I would readily accept that that is the sort of question that you could begin to characterise as concerned with sort of operational matters that is uniquely within the police's purview, because it's essentially saying, does this sort of concept match up and align with the way that the police bodies are structured, if I can put it that way? But contrast all the other questions. So question number 1 is effectively saying, right, we're thinking about cumulative disruption. Should we give the police a discretion to take that into account, or should we make that mandatory? And we get a response that comes back and it talks about Human Rights Act considerations and the like. Question number 2 is asking another question of policy about whether or not police should be able to take into account the effect of future processions. So this was part and parcel of this idea of cumulative disruption and how broadly it goes. And one can see just the first line of the response. There's a question raised about whether any such amendment is even needed. Question 3 is about the way in which and the breadth with which the term area is defined, which is part and parcel of ascertaining serious disruption. Question 4 is obviously highly pertinent to our ground 1, removal of the term significant and prolonged from the definition of serious disruption. And note the response we get back from the police bodies, second chunk of green text. It's difficult to see how a delay to the carrying out of normal day-to-day activities that is not significant could be considered serious disruption, but we'll see if it makes it into the bill. Question 5 is touching on a topic about what's been called absolute disruption, and it's this idea of should the police be able to take into account the sort of disruption that an area suffers day to day, irrespective of whether a protest takes place. And we've got sort of questions of policy being posed back to the government. How do you measure this? Surely context is everything. This sounds like it's removing officer discretion. All of these sorts of thorny issues of principle, if I can put it that way. And question 6 is another question of principle. Should we allow the police to be able to impose blanket conditions on separate conditions that are sort of linked, coordinated under an umbrella of one body? And the question posed back is, well, how would this work? So I just wanted to take some time on that document, just to make the point that the Divisional Court was right to think that this wasn't narrow consultation on technical points of detail and implementation. It was consultation on some of the fundamental principles of policy underlying the regulations that got to the balance of fundamental rights versus the interests of community. And the final point I want to make on the facts is this. This is a case where the Home Office itself described what it did as consultation and did so in documents put before Parliament. Now, I don't say the mere use of the word consultation is determinative. Of course not, we have all the case law on that. But in my submission, where that term is being used, in formal documents that one might reasonably consider had been reviewed by lawyers, it's at the very least relevant. I put it no higher than that. It's at the very least relevant, but not determinative. And there were 3 places where we see the government describing itself as consulting. The first place was the economic note. And I'll just give you the references. I don't think we need to turn it up. It's quoted at paragraph 29 of the judgment, and you'll find the relevant part of the note itself at Supplemental Appeal Bundle, tab 3, page 232. Secondly, it was in the draft explanatory memorandum. See Supplemental Appeal Bundle, tab 33, page 269.
33.
Yes, page 269. And just as a bit of a sidebar on the explanatory memorandum, the draft accompanied the regulations when they were laid before Parliament in April. Liberty sends a pre-action letter in early June. The regulations are made subsequently, and the final explanatory memorandum removes one reference to consultation and instead replaces it with a reference to targeted engagement. But then the next paragraph uses the verb consulted. So it's not a perfect fix, but there was a bit of a change before and after the pre-action letter.
Sorry to interrupt. Just so I've got the right reference.
Yes.
The economic note, you said paragraph 29 of the judgment, then you said supplementary appeal, divided 3, page 232. Are you sure that's right?
Oh no, you're quite right. It's tab 32.
Well, it might just be helpful because otherwise we have to find it all
Sorry,
by ourselves.
you're right.
Let's
It's
just check.
so the economic
Yeah, that
note.
is economic note. That's fine.
Yes.
So I'm with you so far. And then the other one was 32.
The explanatory memorandum, the draft explanatory memorandum is tab 33 and it's 269. If you wanted to see the final memorandum, just for the compare exercises behind tab 37.
So, something I never had to think about before. So what, you're saying that the draft explanatory memorandum is actually published to, what did you say earlier?
it accompanies the draft regulations. So the draft regulations are laid in draft before Parliament. This was a case where it was affirmative resolution, so they don't come into force unless and until Parliament approves a resolution approving them. But when they're laid in draft, we have a draft explanatory memorandum, we have the economic note, and they're published.
So the final form only happens after they've been approved, will have force of law, the final explanatory memorandum.
Yes, I assume they might go
The
simultaneously.
purpose of the explanatory memorandum was to explain to members of Parliament before they enact the legislation what it is that they are approving. So to approve it after, sorry, to finalise the explanatory memorandum after it's been gone through seems a bit odd.
It is slightly odd.
Maybe this because this is actually an interesting point of parliamentary procedure. But I appreciate it's a footnote point for today, so let's spend any more time on it. Ms. Hannah, if you happen to know the answer.
Not off the top of my head, my lord. I'll see if we can find out.
It was amended in part to reflect the criticisms of the Secondary Legislation Select Committee, so they
Well, Mr. de la Mare gives me the context that apparently it was amended in order, in part, to reflect the criticisms of the House of Lords Scrutiny Committee. So that might have been part and parcel of the genesis. But I take the point that it.
Closing the sacred law after the horse has gone through.
Yes.
Okay.
So I think I gave you the two references to consultation. The third one was the evidence given by the Secretary of State to the House of Lords Scrutiny Committee. The House of Lords Scrutiny Committee. And just to be absolutely clear, all I'm doing now is relying on that Scrutiny Committee report for an account of the evidence that was in fact given to them. So I'm not relying on it for the conclusions reached, just the uncontested fact of the evidence. Having regard to Ms. Hannett's submissions, you'll see the relevant quotation at paragraph 42 of the judgment.
And I mean, you've gone over 32 to page 250, the A3, which was the economic note, because Sir James made a specific point. Well, consultation wasn't meant in the formal sense of the word, and at paragraph 9 it said specifically no public consultation by the government. Did you want to comment on that, so we have your submissions?
So, as with the explanatory memorandum, part of the story with the economic note is that there were two versions. I don't think we've ever quite got to the bottom of which version came first and why it was changed and when it was changed, but you might have recalled seeing it in the Divisional Court's judgment. I'm going to infer that they were this way round for this purpose. If one looks behind tab 21, I'm going to call this version 1 of the economic note, and if you could turn to page 31, sorry, and it's page 232. And I was just going to make the point that if you read paragraphs 8 through 10, we've got the paragraph 8, a reference to certain bodies being consulted. Paragraph 9, full consultation wasn't necessary. And it goes on to say, as the provisions in this instrument serve to clarify existing police powers and do not create new powers or criminal offences, and then we get the reference to targeted engagement. There's another version of the economic note, which is behind tab 32. And one goes to page 250, and there's a slightly different set of paragraphs there. It still says no public consultation, but I just wanted to flag that as part of the context. And I take the point that both of those versions are sort of qualifying the word consultation there. But it's part.
I hadn't gone. paragraph 9 in version 2, the recorded version 2. Yes, I see. Thank you.
But if you're relying on it for, I mean, the evidence to the extent that the name can be relevant, which it obviously can be, but how far it's been, how do you deal with the fact that they're saying in terms there wasn't?
Well, my emphasis was going to be in the second version that we see behind tab 32, it says no public consultation. And so when one reads that, that's consistent with there being a sort of narrower consultation, public consultation having the connotations of, you know, formal consultation paper put out to the public, 6 weeks to respond, that sort of thing. So there's a sort of difference in emphasis between these two versions, and that it goes no higher than that. And I accept that, of course, in the other version we've got this reference to targeted engagement, but one reads that alongside.
So doesn't appear in either version of the economic data, but it appears in the explanatory memorandum. Am I just...
We do get it in
you're
tab
quite right,
31.
sorry.
We get that in tab 31, yes.
So, I mean, if one puts that on a jurisprudential basis, Cochrane says if you do a voluntary consultation, you've got to do it properly. I think everyone understands that, and that's common ground to the law. So, you're contemplating here a narrow voluntary consultation rather than a wider public consultation.
Yes, exactly. I accept as part of my case that one can have a consultation completely consistent with procedural fairness that doesn't amount to consulting the public at large. And so the crux of this case, and the way we always put it below, was that the flaw in what the government did, and we framed it in a negative sense, is the failure to consult anyone that could be representative, reasonably thought to be representative of the interests of protesters. So we're not saying go consult every single protester, consult the public at large. There is scope within the standard of fairness for narrower exercises, and I'm going to come on and develop what I say the criteria are and all of that, but that's just the headline for now.
The criteria as to then this
As to-
obligation to have the
Precisely.
narrower but not public consultation.
Precisely, yes.
Okay, thank you.
So that's what I wanted to say on the facts. I'll turn then to section 2 of my submissions, which is whether or not these facts show that the government embarked upon a voluntary consultation. And here the debate between us is really whether the Divisional Court erred in law by treating...
Just, you moved on from the facts.
Move on from the
So
facts.
what's your next heading?
Whether there was voluntary consultation. And the question is whether the Divisional Court erred by treating the criteria in Evely as representing the touchstone test for consultation. And the question really is, are the Evely criteria necessary but not sufficient, which is Sir James's case, or on my case, necessary and sufficient for consultation? And I have 4 submissions as to why this court ought to endorse the conclusion that the Evely criteria should be the touchstone test, if I can put it that way. My first submission is that when one reads Evely as a whole, it is clear that what the Court of Appeal is trying to do is articulate the touchstone test for when one is consulting. And to develop that submission, if I could ask your lordships to turn up the key passages of Lady Justice Lang's judgment, which will be Authorities Volume 2, I believe, tab 44. And page 1137.
Thank you very confusing that we have Mrs. Justice Lang, Lady Justice
Elizabeth Lang, apologies.
Paragraph.
It's paragraphs 81 and 82, which is page 1137. And I'm going to go through these paragraphs quite slowly, if I may.
Yes.
So the point firstly made in paragraph 81 is that the question of whether engagement amounts to consultation is a question of substance, not form, common ground between the parties in this case. And the mere fact that a public authority describes its activities using the words consultation has no magic to it. Now you can see that halfway down 81, Lady Justice Lang says, for this reason, the repeated use by the disability unit of the word consultation was legally irrelevant. In my submission, that has to be read with the sentence before it, which is the mere use of the word cannot entail legal consequences, especially if that word is used by people who are not lawyers. I don't think she's saying here that any time anyone uses the word consultation, it's completely legally irrelevant. I think she's saying on these facts, because this was essentially a sort of policy strategy exercise, the fact that these sort of policy officials used the word consultation was irrelevant on those facts, but I submit that on facts of this case, we have documents of a slightly different nature and formality. So 81 is common ground, but that's setting the scene. The first sentence of paragraph 82 notes that the judge below did not explain what test he applied when deciding that the survey was a consultation which attracted legal obligations. So the vice of the judgment below was the failure to articulate a test. Then we get the second sentence. In my judgment, the gunning criteria are based on self-evident assumptions about the characteristics of the exercise to which they are able and are intended to apply. And there are three aspects of Evely, which in my submission suggest that what Lady Justice Lang is trying to do is provide and articulate the test. First point is identifying that the judge below had
So
failed.
trying to articulate what test?
That the test for when one is consulting in a public law sense. So when one is voluntarily consulting rather than merely engaging. The first point is opening this paragraph with the vice that the judge below hadn't articulated the test. The second point is that in her second sentence, the words and are intended to apply are in my submission vital. Because if all she had intended was to say, look, the gunning criteria are a base minimum, it would have been enough to say, these are the characteristics of the exercise to which the gunning principles are able to apply. But she goes further and she says, these are the characteristics of the exercise to which they are intended to apply. And my third point is that there's a notable absence of anything else in any of these judgments to suggest that the Court of Appeal thought that there might be some other as yet to be articulated criteria which delineates the line between engagement and consultation. So that's my first submission, which is about how one construes and the weight one places upon the analysis in Evely.
Can I just ask, I mean, is it your case then that all the gunning criteria were satisfied in this case?
Yes, and that's what the Divisional Court found. And it's important to note that Sir James didn't say yesterday, well, if I'm wrong about the test, I'm going to say that the Divisional Court erred in the way that it went about finding those criteria satisfied. His case is that they applied the wrong test.
And you will take us through that to make that good.
Yes, I can take you through the Evely criteria. So my second submission is that the criteria that we derive from Evely represent a relatively tightly circumscribed notion of consultation, which still leaves government with considerable freedom of manoeuvre. And the criteria that we derive from Evely are really three things. One needs a sufficiently crystallised proposal. which is likely to impact a particular person or group, usually adversely, and which is put.
So that's all part of the first one. No.
Sorry, so I was going to split them in this way. Criteria 1, sufficiently crystallised proposal.
Oh, I see.
Criteria 2, which is likely to impact a particular person or group. Criteria 3, which is put forward at a formative stage. And pausing there, that last concept of put forward at a formative stage, in my submission, can usefully be unpacked a little further. If one thinks of reasoning backwards from the gunning criteria, of course, the fourth gunning criteria is the requirement of conscientious consideration by the decision maker. And so I think what is necessarily implicit in that formative stage criterion is this idea that you have a decision maker putting forward a proposal with an invitation to respond, with an indication that any response received may inform the proposal ultimately adopted.
Is this you matching what you say happens to the gunning criteria?
So just to be clear, in Evely, Lady Justice Lang is saying the exercise we're going to do is sort of reason backwards from the gunning criteria, and that's going to tell us something about the exercise that these criteria are designed to
And
apply
in that
to.
case, because it was so broad policy.
Because it was so broad policy, they failed at sufficiently crystallised proposal. But she articulates the other characteristics that one derives from gunning. So she articulates the impact on a personal group, put forward at a formative stage.
Could I just ask, I've just been looking at paragraph 95 of the, which is Lord Justice Bingham, who states the position quite pithily and with a degree of clarity. Do you accept that that's right, or that Lady Justice McCurdy agrees specifically with Lord Justice Bingham? So that's
Yes, save that I would add that what's missing from Lord Justice Bean's summary that one gets from Lady Justice Lang's summary is this idea that it's being put forward at a formative stage. And I'll just take you to the relevant paragraph. And it's paragraph 85 of Lady Justice Lang's decision, page 1138. Perhaps if I could invite you to read that, that's really the point that I'm developing at the moment.
113.
1138, it's paragraph 85.
Oh, sorry. Well, which paragraph? 85.
85.
Yes, I see.
Do you have the full gunning criteria anywhere that we can just look at? They're not set out in this judgment, are they?
No, but I could
So
give you
they're
another
near the
reference to
authorities.
them,
One-
because they're endorsed in Moseley.
Yeah, it's just so that we can.
Yes.
Refer,
Yes, so if you go to Authorities Bundle, tab 26, and it's page 554. And it's para 25, where we have a quotation from Gunning.
Can I just ask this, which has bothered me ever since I see this. If the gunning criteria are satisfied, no one can bring a claim because you had a proper consultation. And if you are actually sort of saying, well, the way to work out whether there is a duty to consult is to look at the gunning criteria and see if you're satisfied, the whole thing becomes completely circular. Or is that wrong?
My answer to that is it's wrong to say that the gunning criteria are exhaustive of the requirements of procedural fairness. And what do I mean by that? Well, our case is a case in point where we say the flaw in the consultation exercise was the one-sided nature of the group of consultees. In other words, there was a flaw with the decision about who you're consulting. Now, that's not a gunning point. It's a broader fairness point. And I can take you to one authority briefly just to support this idea that one shouldn't take gunning as exhaustive of what a fair consultation requires. And that's the judgment of Medway. So that's behind tab 16.
You mean 16?
Medway Council, 16 in my bundle. Page 322. It might be that because it's a strange law report, that the document's headed publication of consultation
Yes, thank you,
document.
yes,
So,
that's what-
yeah, sorry, that's the issue. This is the only law report I could find of this case, and it's a slightly odd one, I apologise. Journal of Planning Law. If you go to 314, you can see but it's 322.
Hang on, I'm being slow. Yes, I see. Well, this reads like a case note.
No, it's the full judgment.
Case comment, but the actual judgment appears somewhere. Does it?
Yes, so the judgment begins page 316. So it's,
So there's a held note on 314.
yes, head note begins 314, judgment, full judgment begins 316.
But yes, 314 effectively is the head note.
Yes, sorry.
Okay.
And
So which particular paragraph are you going to see?
so it's paragraph 28, and it's bottom of page 322.
Read the whole paragraph, yeah?
Yes.
So Coughlin just reiterated the four requirements are done.
Yes, and the point that's being made in this paragraph is to say that it would be wrong to say that after Coughlin, the be-all and end-all is the gunning requirements. Rather, the standard is fairness. And the reason why that mattered on the facts of this case, it's a case I'll be coming back to, but it's a case where effectively the government had chosen to consult on option A. And the challenge was, because you've decided to consult on option A, fairness demands that you consult on option B. And in broad terms, it was a consultation on options for airport expansions. And they deliberately didn't include the option of expansion at Gatwick. And so the challenge was, well, hang on a minute, if one looks at the sort of decision-making process as a whole, you're closing down the only opportunity we might have to say that actually Gatwick is the right option. So it wasn't a gunning challenge, it was a sort of broader fairness point, and that's how that point comes up. So on a case like this, one could readily see how one could have a consultation exercise that's completely gunning compliant, but that is nevertheless unfair because there are other things to look at, if I can put it that way. Sorry, so we were looking at the gunning criteria in Moseley, and I was developing the submission that the fourth gunning criteria is that the decision maker has to conscientiously consider the consultation responses received. And I was developing the idea that the criteria, the touchstone test for consultation that we see in Evely, namely sufficiently crystallised proposal, which is likely to impact a particular personal group, and which is put forward at a formative stage, can just be unpacked a little bit more. and I'm sort of driving at the idea that what's implicit in the Gunning criteria and the Evely criteria is this idea that the decision maker is deliberately soliciting views on a proposal for the purpose of forming a view on whether or not to adopt the proposal in those terms. So it's a putting forward of a proposal, with an invitation to comment and an indication that you'll take those comments into account. And the reason why I want to sort of spell that out is because in my submission, once one understands that that's what's really the central case of a consultation, one can then distinguish a number of the other exercises in the case law that have been held to not amount to consultation.
So well, if it's so important that I just did it down, but if this isn't the Gunning criteria, is the decision maker is deliberately seeking what was your
Soliciting views on a proposal for the purpose of forming a view on whether or not to adopt a proposal in those terms.
Can I just ask, now that we have page 554, and thank you for Gunning criteria, is your case then not that you need to satisfy all the Gunning criteria, because otherwise it suggests it might become circular? You're saying the first two that you say show that it's there's a follow-up consultation. Because I mean, it's common ground you don't satisfy the fourth, otherwise we would be.
Yes, it's the first two, yes.
So you say that if you satisfy the first two, then you've got the key of a voluntary consultation. Is that a fair summary?
Well, what I'm relying upon is the criteria that are derived from Gunning requirements 1 and 2.
Yeah.
So in Evely, they start with the requirements and they say, what characteristics can we infer a consultation must have? So the idea of a sufficiently crystallised proposal is linked to this idea that you have to sort of give sufficient reasons to enable an intelligent response. And that was the flaw, that was the problem in Evely. They had a sort of inchoate strategy document that effectively said, we're thinking about what to do in the realm of disability rights, tell us about your experiences. There's no crystallised proposal that would allow someone to respond. So that sufficiently crystallised proposal likely to impact a particular person or group. Now, one doesn't get that from the Gunning criteria, but Lady Justice Lang says when one looks at the sorts of cases where the Gunning requirements have been discussed, those sorts of cases involve a proposal that's going to impact a particular group. And the put forward of the formative stage does match quite neatly with the first Gunning requirement.
Does Gunning say anything about the
No, Gunning itself, the Gunning principles themselves don't talk about the selection of consultees,
which is what your case is about?
which is what my case is about. But as I'm going to come on to, this is jumping ahead a little bit, but we're going to establish that there is case law on this particular point, which is, does fairness extend to the question of who you're consulting? But for present purposes, what I'm trying to get at is the idea that there's a sort of there's a purposive element to consultation. A purposive element. Your purpose is putting forward a proposal with an invitation to comment for the purpose of taking those comments into account.
There can be no such thing as targeted. Every targeted engagement will be a consultation. The purpose of the targeted engagement will be to solicit views from the person who you are soliciting from, for the purpose of considering whether to adopt the proposal.
Well, in my submission, if I could give you 3 examples of cases where these criteria aren't met and which show the sort of spectrum of activity that wouldn't be caught by these criteria. First example, the Evely criteria won't be satisfied in those cases where the government is asking targeted questions of particular persons to obtain information without reference to any proposal as to what it's going to do. So, for example, a decision maker could go to an independent expert and say, what do you estimate the downstream greenhouse gas emissions to be of this particular project? No consultation because there's no putting forward of a sufficiently crystallised proposal. Second example, which is really the Evely case. The Evely criteria won't be satisfied in those cases where the government is asking a wide range of stakeholders questions in order to obtain information to develop some future proposal down the road.
Well,
So-
not information, views.
Views or information, yes. So what one could have on the facts of Evely, a survey that asked for one's views on the most pressing issues affecting disabled people today. Or you might ask for information on the challenges that they suffer day to day. Not consultation, because it's not a putting forward of a sufficiently crystallised proposal and asking someone to say whether one ought to act in those ways. And my third example, and this is why I was sort of unpacking the Evely criteria, is that they won't be satisfied in those cases where the government has taken a decision and is telling stakeholders what it's going to do, not for the purpose of inviting feedback, which will then be taken into account in taking the decision, but for other purposes. And both the FDA case and the personal injury lawyers case are examples of this kind of activity. So the FDA case, which Sir James referred you to, but just by way of recap, on the facts of that case, the government had taken a final decision about civil service pay. Having taken that decision, it had then held a meeting with trade union officials and communicated its decision to those officials, not to solicit union comments on that proposal, but rather in order to try and maintain trade union relations at a time when they were particularly fraught. So there's a different purpose there. And that's what Mrs. Justice Simler, as she then was, found. She said this isn't consultation because the decision had been made, and the purpose of these meetings was to maintain industrial relations. See paragraphs 21, 102 and 104. And the other example is the personal injury lawyers case. So there the government had taken a decision to reduce fixed recoverable costs in road traffic accident claims. Having taken that decision, it then has a roundtable meeting with representatives of the insurance industry where it tells them this is what it's going to do, and it effectively tries to negotiate something of a quid pro quo, because obviously by the time it's publicly announcing, it would be great for the government to say, and by the way, the insurance industry has committed to reducing premiums. Again, it's not the putting forward of a proposal for the purpose of soliciting views that you're going to take into account. It's for another purpose entirely. So all of these are examples of cases where the government is able to engage with stakeholders, obtain information without crossing over the tripwire into consultation.
That doesn't. Whether or not a particular example is, whether the cases which you take as parallel to particular examples are right, the way you formulated it evades the question of whether there can ever be targeted engagement as opposed to consultation. When you have a crystallised proposal, it would mean every time we have a crystallised proposal, if you ask anyone what you think about it, or they think about aspects of it, you've got to ask everyone. When I say everyone, I mean representatives of every possible interest group, every central interest. And in which case, the distinction between consultation and targeted engagement is meaningless.
Can I make two submissions on that? My first submission is that I accept on the test that I've outlined and the test that the Divisional Court adopts, you're going to have a very broad concept of what consultation is. And so I accept that there will be a wide range of situations which on my test would be classified as consultation. But my argument is we don't need to shy away from that, because the sorts of concerns that Sir James was raising can be mediated in a far more nuanced way through the standard of fairness. And it was never our case that if you consult, it follows you must consult fairly, and fairness means in every case, if you happen to receive a view from one viewpoint, you must therefore go out into the world and find another viewpoint. Our case is much more nuanced, and this is going to be developed in section 4 of my submissions, but our case is that there was a number of very fact-specific contextual factors in this case, which meant that balance was necessary. But I would accept, on my case, there remains room for the government to be able to say, yes, we were consulting, yes, it's fairness, but we had a very narrow purpose such that it was fair for us to only speak to A, B, and C. The problem is that we don't accept they're able to make that argument on those facts. So my third submission on the Evely criteria was that the merit of these criteria is that they provide decision makers with a clear yardstick by which to judge whether or not they're consulting, and that will in turn allow for consistent and predictable application. Sir James's suggestion is that one takes the Evely criteria as step one, and one adds a sort of second stage inquiry where one looks at the purpose of the exercise and its nature. And the problem with that test is it begins by taking as one's sort of central case or one's golden bullseye, to use Sir James's analogy from yesterday, your sort of classic case of consultation. And then the sort of further away you get from that, there's an idea that one loses the essence of you're no longer consulting. But the problem is it's hard to know where in the penumbra one draws the line. And of course, given that the public law principles of fairness are hopefully designed to be predictable for decision makers, a test that is clear, that reflects the sort of common understanding of what consultation at its very essence comprises is far superior to a test that starts involving sort of evaluative judgments based on purpose and nature and so on. And my fourth submission is that none of the broader factors relied upon by Sir James as to the purpose and the nature of this exercise leads to the conclusion that this was not consultation. And so I'll just address the different arguments briefly. In terms of purpose, Sir James said the purpose of the exercise in this case was narrow. It was about getting input from the police from a police perspective. One difficulty with that kind of argument is that, of course, the characterisation of what is going on can be disputed. And this was a case where the Divisional Court, rightly in my submission, challenged the characterisation that this was all terribly narrow. And they make a number of findings that, in fact, this exercise is very broad, and that's why I took your lordships to the response document to show you the kinds of policy questions that were being put and discussed. But for your note, you can see what the Divisional Court finds at paragraphs 163, 165, and 185, Roman numeral 3. A second kind of difficulty with this argument is that it involves a level of circularity. So it allows the government to say, oh, I wasn't consulting because I didn't want to hear from anyone else. But that sort of argument is a slippery slope. Consider, for example, the facts of Article 39. That was a case in which the consultation consisted of the government putting out draft regulations to local authorities, Ofsted, and social work agencies. It was no answer in that case for the government to say, well, we weren't consulting, we just wanted to talk to these groups of people. The Court of Appeal said, no, you needed to have consulted more broadly.
But that was a statutory consultation.
It was a statutory consultation. However, and perhaps if I could take you into the judgment. I'll show you first what happened. If one goes to Authorities Bundle, Volume 2, tab 37, and it's page 896. And it's paragraph 7, just outlines what happened in fact in this case. And then, if your lordships could turn to page 924. And it's the first sentence of paragraph 78. Now, I entirely accept the point that, of course, the Court of Appeal goes on and finds that on the facts of the case there was a duty to consult, but it's relevant in my submission and notable that at paragraph 78, Lord Justice Baker begins by saying, well, irrespective of whether or not there was a duty to consult, the fact is the Secretary of State did consult. And in my submission, the facts of Article 39 are on all fours with what happened in this case. A sharing of draft regulations, draft legislation, to other sorts of public authorities that you might be able to say were the kinds of authorities that would end up making use of the regulations. So in this case, the sorts of authorities that would make use of the relaxed procedural standards around children in care. Still a consultation. And so one of the difficulties is trying to reconcile that finding Article 39 with the suggestion that a different conclusion should be reached in our case.
Where does the court or Lord Justice Baker say that what's described in paragraph 7 of the judgment amounts to a consultation to allow him to conclude paragraph 78 that in fact he did consult?
Well, the conclusion is that sentence of paragraph 78.
But is there any reason as to how you get from what happened in paragraph 7 to the conclusion in paragraph 78?
No, there is no reasoning. One doesn't see, for example, an articulation of the test he's applying. But I just rely upon it to make the point that if it were open to the government to say, no, we weren't consulting because we only wanted to talk to this narrow group of people, it could have made that argument in that case, but it didn't. So that's the purpose of the exercise. I then wanted to address Sir James's submissions on the nature of the exercise. One submission he made was that it's very important to recall that this was consultation or engagement about amendments to a bill. And that led to his submission about parliamentary privilege and the fact that Liberty wouldn't have been able to complain on, say, the 22nd of December had it known that there was this engagement going on. My first point is that the principle of parliamentary privilege is best seen as a principle which goes to remedy. It's not an immunity principle. So Sir James took you to the police superintendent's case to make good the point about parliamentary privilege.
I don't understand what you mean by saying goes to remedy.
What I mean is the parliamentary privilege principle prevents the court from making a remedy which trespasses upon the freedom or questions the parliamentary proceedings. And so in the case law, the courts have said we cannot give an order, for example, compelling a minister to consult before he introduces a bill into Parliament, because that would be to bind his hands to prevent him from doing something in Parliament.
I thought in principle it's to the remedy of admissibility of evidence. Nevertheless, be very essay, but at the end the court say, we should not look at this because it involves something Article 9.
The police superintendent's case is an interesting illustration of my point, because in that case, the court goes through the consultation argument, forms a conclusion that something had gone wrong with the consultation because the responses had not been considered by the decision maker before they took the decision. And it's only at the relief stage that the parliamentary privilege principle kicks in, and it says, well, we can't make an order prohibiting you from introducing this legislation. And the reason I make that point is because I just want to make clear that it cannot be the case that the government can say, well, this legislation at one point was going to be pursued through primary legislation, and so it's not open to you to sort of consider the merits of what went on in that particular window of time. The fact is that these regulations were made by way of secondary legislation, so there's no bar to this court making an order which says that the consultation process is unlawful. And my submission is that one is to view the consultation exercise in the context of the decision-making process as a whole. And what I mean by that is the decision-making process stretching all the way through to the decision to make the statutory instrument, which is the effective decision. That's what brings it into force.
Can I just ask this, because an answer on parliamentary privilege, you may or may not be right about the police superintendent's case, and my lord's point is quite accurate. But what wasn't the main point about it being a bill was that they were consulting on a bill. They didn't speak to anyone about the regulations. True, they use the same formula. I mean, suppose you do a bogged up consultation. How long does it have to sit on the shelf before it's, the earlier bogged up consultation informs its use in a different way?
Well, in my submission on these facts, it's clear that the very same measure that they were consulting on becomes the regulations. There's no sort of substantive change in between those two bits of legislation. And so I say there is one coherent decision-making process stretching from the beginning of the consultation through to the making of the secondary legislation. And the question for your lordships is, was there a fair consultation in the context of that decision-making process as a whole?
If there was a requirement.
And I had taken your...
distinction between secondary legislation which is passed by the affirmative resolutions and the Parliament form when no affirmative resolution is required. Because by definition you are asking us to quash.
Yes, I would submit that there's no distinction. The statutory instrument, not.
You are asking us to quash regulations which have been debated in Parliament.
So there's no bar to us challenging these regulations simply because they were regulations made pursuant to the affirmative resolution procedure. The target of the challenge is the decision to make the statutory instrument, and that's an executive decision.
Well, I see that sort of works at a theoretical level, but where parliamentary privilege, it may not be quite as straightforward as that.
One of the submissions that found favour with the Divisional Court below was that if that were an answer to all of these kinds of challenges, it would have been an answer in Article 39, and it wasn't.
Yeah.
And so we say again, this case is very much analogous to Article 39, and that's for good reasons of principle as well. There's a sort of softer argument that your lordship might make to me, which is, all right, we might not be barred from quashing the regulations on grounds of procedural unfairness, but to what extent are we to take into account the scrutiny that they're given before Parliament, which is inherent in the sort of negative or affirmative resolution process? And our answer to that is to say that no reasonable decision maker could have thought the sort of parliamentary scrutiny that comes with secondary legislation is an adequate substitute for consultation at a formative stage. One of the key limitations upon the ability of Parliament to scrutinise secondary legislation is that it has no power of amendment. And so there's sort of one threshold argument, which is by the time that the Minister has laid draft legislation before Parliament, we're long past the formative stage. The die is cast, Parliament cannot change, it can only vote yes or no. And in any event, and this was very much the subject of the witness statement from Professor Tomlinson that was filed by PLP, it's well recognised that the ability of Parliament to scrutinise secondary legislation is extremely attenuated. And so we would say on no grounds could one develop a general principle, for example, that every time regulations are made pursuant to the affirmative resolution procedure, you don't need to consult fairly and there's no grounds for a sort of procedural fairness challenge to the same. Sir James then had a submission about the nature of who was approached, and he placed some emphasis on the fact that the police bodies are sort of public authorities in their own right, and he said sort of adjacent to central government. In my submission, it would be wrong to suggest that the police are somehow part and parcel of central government. And it has never been the law that one arm of government cannot consult with another. There are many examples of consultation cases where one layer of government is saying to another layer of government, you ought to have consulted me, or indeed other sorts of public authorities. So Article 39, for example, where the government consults local authorities, service providers and Ofsted. The answer wasn't, well, hang on a minute, we were only talking to public authorities who are going to implement these safeguards. The case of Milton Keynes is another example. That was a case in which local councils were complaining that central government should have consulted them on secondary legislation changing the planning laws. And no doubt one can think of many other examples, for example, in, say, health or education, where you're having government consultations with educational health authorities, that sort of thing. And then Sir James placed emphasis upon the fact that these policy instructions and the draft legislation were shared under a cloak of confidentiality. But there's no reason why the government couldn't have consulted more broadly, whilst maintaining a cover of confidentiality. For example, we don't know, but one might reasonably infer that when the draft regulations in Article 39 were put out for comment, they might have been shared under cover of confidentiality given the sensitivity of the subject matter. So we say no, there's no principled basis on which to say no consultation if proposals are put out under the protection of confidentiality. I then just wanted to say something very briefly about the transactional case, which was the additional case handed up by Sir James. We say that case is distinguishable on its facts. That was a case in which, yes, that was a case in which a decision had already been taken to the extent that the minister had announced in Parliament that she was adopting a particular order. And that was the context for what was said to be subsequent engagement about smooth implementation. We say our case can be compared and contrasted because at the time of the consultation, there was plainly no final decision taken. And the issues on which the police bodies were commenting struck at the very heart of policy decisions in the regulations. Before I finish this section, I wanted to then briefly just take you through the Divisional Court's reasoning as to why the Evely criteria was satisfied in this case. If one asks oneself, and really it's paragraphs 163 to 169 of the judgment, one asks oneself, was there a sufficiently crystallised proposal? One can't do very much better than having a draft set of legislative clauses. Was it likely to impact a particular group? Yes, the Divisional Court finds it was likely and intended to have an adverse impact upon those taking part in processions and assemblies. Were the proposals put forward at a formative stage? The Divisional Court says yes, para 165. And it's self-evident from the documents that if we use my sort of unpacking of the formative stage criterion, we have a putting forward of a proposal with an invitation to comment and an indication to the police bodies that their feedback will be taken into account in finalising the regulations. So those were my submissions on the second topic, which is, was there voluntary consultation? The third topic is standard of review. Is it fairness? Is it rationality? what I'm going to do is begin by showing you the development of the general principle that if you choose to embark upon a process, then you ought to conduct that process fairly. So I'm going to show you that in the consultation context, this principle starts life in the Court of Appeal judgment in Haberdasher's case, before being adopted as common ground in Cochrane. I'm going to show you that this principle has its analogues in other areas of procedural fairness, namely hearings, where we have Lord Justice Sedley in a case called Ex parte Paddock, and Miller, which is about investigations. And I'm going to argue that this general principle is a good one because it reflects the different balance of interests and considerations at play once a decision maker has voluntarily embarked upon a particular process. Having established that general principle, I'm then going to address the question of whether the decision of who you're consulting calls for a different sort of treatment. And I'm going to argue Milton Keynes is binding authority, that fairness governs that question, that Article 39 isn't authority to the contrary, and in any event, there's no good reason to take a different approach. So I'll start with a general principle. And this is Haberdasher's School, where I want to go first. In the bundle, we have the Divisional Court judgment and the Court of Appeal judgment. I'll start with the Divisional Court judgment first, just so you can see how the case develops. That's Authorities Bundle 1, tab 8. This case concerned two Haberdasher schools in New Cross, and following a period of statutory education reform, school governors had to decide whether to change the status of those schools. One can see that background at page 98, E through H. And if one turns then to page 100, letter F, we're told that it was common ground that the school governors were under no statutory duty to consult, but that they had nonetheless resolved to do so. So they had chosen to consult. If one turns over the page to page 101, letter G, just above letter G, we can see that counsel for the school governors agreed that having embarked upon the process, the governors came under an obligation to conduct it properly. But the oddity is what the Divisional Court went on to do is then review the governor's decisions about the consultation through Wednesbury rationality. And that point gets picked up on appeal. So I'll take you into the Court of Appeal judgment next, which is behind tab 9. And could I take you, please, to page 112 and ask you to read the sideline passage? And this is the judgment of Lord Justice Wolfe. Page 112. So Lord Justice Wolfe is noting that counsel had agreed to Wednesbury rationality, but he's disagreeing with that, saying, no, the standard is fairness. Lord Justice Balcombe agrees, but he doesn't add anything at page 126. But if I could take you to Lord Justice Kerr at 130, page 130. If I could invite you to read the sideline passage there.
there's a slight difference between Lord Justice Wolf and Lord Justice that Lord Justice Wolf seems to say fairness rather than rationality, and Lord Justice Carr seems to say both.
Both. And there might be some situations in which it might be both irrational and unfair, but he says there might be some situations where it's rational because you did not know of the circumstance which rendered it unfair. So I thought I would just show you those passages because, of course, one of the points made about Cochrane is it's received wisdom, it's not argued, it's not really considered. And my point on the Haberdashers case is it's not argued, but it's certainly considered.
Also, of course, makes the point that in most cases,
it won't really matter, and I accept that point.
It's the same. It's important nevertheless that we get right.
Important nonetheless. So then we have paragraph 108 of Cochrane, where it's Lord Justice Wolf again. He makes this point that if you choose to consult, you have to do it properly. It's common ground, but perhaps not surprising that it's common ground, given what he had said in Haberdashers' case.
So where was Cochrane?
It's tab 15. And then the only other point on the authorities for this general principle, I won't ask you to take it up because I think you've seen it a few times, but it's paragraph 23 of Lord Wilson's judgment in Moseley. For your note, it's Authorities, Volume 1, tab 26, page 553. And he says there, but irrespective of how the duty to consult has been generated, the same common law duty of procedural fairness will inform the manner in which the consultation should be consulted. Now, entirely accept that Moseley is a statutory consultation case, entirely accept the issue on Moseley was the quality of the information. I put it no higher than we can see a series of judgments in which this principle is getting judicial endorsement.
Can I just ask, I mean, all the cases where they say if you start a consultation, you've got to do it properly, have really been cases where it was pretty common ground that people were doing consultation. I mean, the Haberdashers, they decided to go out and consult the families, and you look at the others. I mean, the jurisprudential basis for saying once you start a voluntary consultation, you've got to do it properly is really the fairness.
Yes, and I'm going to come on to why I think the case law is developed in this way. Before I do so, just very quickly, the second submission I was going to make on this point was just to say that the Cochrane principle has an analogue in other areas of procedural fairness. I won't take you to these cases, but for your note, see the remarks of Lord Justice Sedley and Ex parte Paddock. Authorities Bundle, tab 12, in particular page 171. He says there, it cannot be right that a public decision-making body which is not obliged to conduct a hearing may choose to do so, but then may make a charade of it by refusing to listen to one side. So it's the same idea. If you choose to do it, you've got to do it fairly. And then in the investigations context, the case of Miller and Health Service Commissioner, which is cited in our skeleton, that's authority for the proposition that where statute... It's not in the authorities bundle, I apologise, but the reference is in our skeleton.
Which paragraph?
54C.
54C. Thank you.
54.
54C.
C. Just Paddock, why do you say it's analogous? Is it the same point? Or?
Well, it's in the context of hearings rather than consultations. It's all a fair process in a general sense, but it's a slightly different process. And Miller is just slightly different again in that it's investigations. And it's the idea that where statute confers a discretionary power to conduct an investigation, common law will import a duty of fairness. So that leads to the question of why the cases have gone in this direction. And in my submission, there are two things at play. Firstly, on the one hand, I think this line of case law is recognising that the reasons why what I'll call the Plantagenet alliance gateways for a freestanding duty to consult are drawn so tightly, those reasons don't apply with the same force where the decision maker has chosen to consult. And so Sir James spent a lot of time, of course, developing the proposition that, of course, the Plantagenet alliance gateways are deliberately high. That's informed by a need for caution before the law interferes with what is seen as a sort of area of executive discretion. And my submission is that where the executive has, of its own volition, decided that consultation of some kind would be helpful and appropriate, the same need for caution doesn't apply because the executive has already decided for itself that obtaining feedback on a proposal in a general sense is a good thing to do.
But caution about what? The question you're now addressing is simply whether the standard of review is rationality or fairness. Isn't it?
Yes, yes.
So implicit in this is that fairness is a lower threshold than rationality.
Well, fairness is, of course, a legal standard that the court is the judge of. It doesn't have that degree of sort of deference to the decision maker that Wednesbury rationality necessarily involves. And that's Osborne and Prolboard, Para 65. So there may be cases where these two standards march together. There may be cases where they don't. And my second point was that, on the other hand, the choice to embark upon a consultation means that other important considerations need to be placed on the scales. In particular, the sense of injustice that people will feel if they see a consultation occurring on a particular point with certain people that doesn't involve them. Now, that's not to say that, of course, every time someone feels a sense of injustice, it must therefore follow there's a duty to consult. But it's getting at the idea that in these sorts of cases, one isn't saying, oh, well, there's a past practice where you tend to consult on this sort of thing. The decision maker has actually consulted on the topic in question. And it's the idea, I think, the vice of allowing someone to conduct a consultation and then conducting it unfairly is this perceived sense of injustice. And one sees that in the reasoning in Moseley about the purposes of fair consultations. So that's the general principle. One then asks, should we treat the selection of consultees differently? And my first submission is that Milton Keynes is binding authority on this point. Sir James had 2 points on Milton Keynes. Firstly, he said the relevant paragraph, which is para 32 of Lord Justice Pill's judgment, is obiter. And secondly, he says the point about fairness wasn't properly argued. In my submission, this part of Lord Justice Pill's judgment is part of the ratio because it's a necessary part of his reasoning. And he goes on to decide the case on the basis that the consultation wasn't unfair, because when one put that consultation in the context of the decision-making as a whole, you had this prior, much broader consultation, and what was being challenged was essentially something of a top-up consultation. So the fact that the standard is fairness was a necessary part of his reasoning, and in my submission, part of the ratio. See paragraphs 33 and 36 of Lord Justice Pill's judgment. That leads you to the question, well, if it's ratio, can we depart from it? You've obviously got the very narrow principle in Kadim that says if it's neither argued nor considered in those limited circumstances, one can depart from something that's part of the ratio. But Kadim is very clear that that's an exceptional principle, and one should conclude only in exceptional circumstances that a court merely assumed rather than considered a point. And my submission is the standard of review was both argued and the subject of consideration by the court. And to make that submission, it would be helpful if your lordships could turn up Milton Keynes. So that is Authorities Bundle, tab 23. So I think that would be volume 1.
Sorry, which
So it's tab 23. I'm going to start on page 506, and it's paragraph 17. I'm going to take you through the submissions in a little bit of detail just to make this point. At paragraph 17, the Claimant's Counsel acknowledges that the Secretary of State was under no statutory duty to consult, and the Secretary of State's Counsel, Mr. Morshead, accepts the Cochrane principle. If one then moves over to paragraph 18, and I think here the court is reciting the submissions made by the Claimant's Counsel. He notes the submission made on behalf of the claimant, this is halfway through paragraph 18, that the fairness of the consultation necessarily included a fair approach as to what parties should in the circumstances be consulted. And then if one jumps ahead to paragraph 26 over the page, the court is then reciting the submissions made on behalf of the Secretary of State. And in paragraph 26, the submission that is being made there is that the decision isn't immune from review, but rather because of its context, there should be some sort of light touch Wednesbury review only. And so he places emphasis on Lord Justice Laws in Begbie. And then at paragraphs 27 and 28, over the page, we have two more authorities cited by the Secretary of State, which are broadly going to the idea that there should be caution before imposing a duty of consultation on, for example, legitimate expectation grounds, and the discretion which decision makers have about the way that they run consultation exercises. That's all the context for what comes in paragraph 29, where Lord Justice Pill says, on the strength of those authorities, Mr. Morshead first argued that the decision maker can decide whom to consult. And Sir James characterised that, I think, as a submission that it was an absolute discretion, not subject even to Wednesbury review. But in my submission, that reading is hard to reconcile with what comes in the preceding paragraphs. And I think the submission, in fairness, was more nuanced than that. And really, I think the force of the Secretary of State's submission in this case was the sort of point that Sir James has been making, namely that if you can't satisfy the criteria for a freestanding duty to consult, see Plantagenet Alliance, then that's decisive. And then that is all the context for paragraph 32, which of course is the really crucial paragraph of Lord Justice Pill's judgment, where he said a fair consultation requires fairness in deciding whom to consult, as well as deciding the subject matter of the consultation and its timing. And in my submission, when you read that paragraph in the light of what precedes it, Lord Justice Pill is giving proper consideration to the standard of review. He's rejected the submission that you treat decisions as to whom to consult differently from other kinds of decisions. He's rejecting the submission that this is sort of light touch Wednesbury review. And he's rejecting the argument that, well, you can only complain if you satisfy the conditions for a freestanding duty to consult. And the final point I would make on Milton Keynes is that when Lord Justice Pill goes on to ask himself, well, what does fairness require on the facts of this case? He doesn't ask himself, was there a legitimate expectation? Was there a statutory duty? Was there conspicuous unfairness? What he actually does is a sort of all things considered, close look at the full factual context to reach a considered view on fairness. And that's the exercise that we say the Divisional Court undertook and was right to undertake. So that's why I say Milton Keynes is binding. Then we've got paragraph 35 of Article 39, which is that part where we have the citation of Liverpool and the brief reference to a decision can be challenged on rationality basis. In my submission, it's not a fair reading of that part of Lord Justice Baker's judgment that he was saying rationality is the only ground on which one could challenge that sort of decision. In the immediately preceding paragraph, at paragraph 34, he cites Lord Wilson, para 23 of Moseley, where he says, irrespective of how the duty to consult is generated, the common law duty of procedural fairness will inform the manner. So we've got that slight tension between 34 and 35. In any event, Milton Keynes wasn't cited in Article 39, as far as we can tell from the judgment. So even if one were to put particular weight on paragraph 35, my submission would be that it's in per incuriam. And just for good measure, I should note that this analysis accords with the views of Mr. Justice Linden in the first instance judgment in the medical justice case, which I won't take you to, but you've got that. It's Authorities Bundle, tab 45, page 1167.
Just as a matter of fairness, so you heard an appeal on that. Just so you know,
Yes.
It's slightly unfair to say it, but you know, it's much fairer if you can do that.
Your lordships will know better than me. I wasn't aware that that point was in dispute on the appeal in medical justice, but of course I can be corrected.
Consultation was.
But the question of whether they had been consulting, I think, was, but not the question of if it was consultation, what the standard was. Yes.
Which paragraph were you referring to? In Justice Linden's judgment.
So it's the it's paragraphs 97 through to 104. That's pages 1165 through to 1167.
Okay.
So that's the authorities. What about the position in principle? No good reason to treat the selection of consultees any differently from all sorts of other kinds of decisions about how one designs and conducts a consultation. And here, the cases have recognised that a decision to consult upon option A might trigger an obligation to consult on option B. And I'll just give you the references rather than turning those up. It's the Supreme Court judgment in Moseley, paragraphs 27 to 28 of Lord Wilson's judgment, Authorities Bundle, tab 26, page 555. And there he cites Medway, which you also have in the Authorities Bundle for the same point. And we say if a decision to consult on option A might, in some cases, lead to triggering a duty to consult on option B, it's very difficult to see any reason of principle why a decision to consult person A might not trigger a duty to consult person B, always depending on context, fairness, it is not a strict standard, and so on. So that is what I was going to submit on the third set of submissions, which is standard review. And finally, my fourth section is what fairness, alternatively rationality, required in this case. I'm going to quickly address the test for fairness, quickly address the reliance on the House of Lords Scrutiny Committee reports, and then go through the attack on the Divisional Court's reasoning. Sir James places too much weight upon the reference to a broad standard of fairness in paragraph 183. Reading the judgment as a whole, it's clear that the Divisional Court had well in mind the need to apply a standard of fairness which grants a degree of latitude to the decision maker. See paras 181, 183, Roman numeral 8. And furthermore, the language itself, the reference to a broad standard of fairness. Paragraphs 181 and 183, Roman numeral 8. And I was just going to make the additional submission that the very phrase broad standard of fairness is equally capable of being read as the Divisional Court saying, we're applying a standard of fairness which is broad in the sense that it's not unduly prescriptive and might admit a range of different approaches. So far as the scrutiny committee reports are concerned, we accept that no weight ought to be placed upon the conclusions reached by the committee. But for the purposes of this appeal, the question really is, to what degree did that infect the Divisional Court's analysis? And in my submission, when one reads 182 to paras 183, the court has well in mind that it's its own responsibility to form conclusions on fairness. It lists its own 8 reasons, which are different from the reasons given in the committee report. And there are a few instances, I accept, where the court expresses itself in terms of endorsing or agreeing with something said in the committee report. We accept it would be preferable not to have done that, but nevertheless, it's not the court saying this reason we are identifying and giving weight to only because it is in the committee report. In our submission, one could sort of take a blue pencil and strike out the references to the committee report, and one will be left with a list of reasons that are entirely justified. 3 overriding submissions then on Sir James's attack on the reasoning at paragraph 183. One argument Sir James used was to take each reason in isolation and say, well, that's never been enough to generate a duty of consultation on a freestanding basis, so that must be a bad point. Our answer to that is we don't have to establish a freestanding duty to consult. Our case is that fairness can require something different when the decision maker has already chosen to embark upon that process. Another argument Sir James made was to take each reason in isolation and then say, well, that logic proves too much. If that's all you need to show, then we're going to be having findings of fair consultations all over the shop. But our answer to that is that's a misreading of what the Divisional Court does. The court relies on a combination of different contextual factors that work together to make this case one which, in its view, was on the extreme end of the spectrum. And then my third overriding point was there can be no criticism of the Divisional Court's failure to specify a positive case as to what would have been fair. It is entirely appropriate for the court to express its views in the negative. Just as there's no one rational way to go about decision making, so too there is no one single fair way of running a process. And the role of the court is to identify why the process adopted by the decision maker was unfair and not to specify what the fair option was. And if you needed authority for that, see the off-cited remarks of Lord Justice Sedley in the case of Turlock and Berezovsky at paragraph 20. So I'll quickly address then the shopping list of criticisms, if I may, of para 183. Para 183, Roman numeral 1, this was the idea of that the regulations led to an increased exposure to criminal sanction. We accept the economic note with the estimations of how many prosecutions would follow and how many custodial sentences would follow was an estimate. Nevertheless, that estimate is informative, and it's really putting meat on the bones of my point that from the get-go, from its very inception, the intended purpose and effect of these regulations was that they would be used to increase the number of conditions placed upon protest activity. Sir James also glossed over another very important point in paragraph 1831. And this is the point that the Secretary of State herself said the reason why she did not consult more widely was because the regulations created no new powers or offences of a criminal nature. And that reasoning, and you see this in the judgment, appeared in 3 different places. The economic note, which accompanied the regulations, quoted at judgment paragraph 29. The explanatory memorandum accompanying the regulations, see paragraph 139. And then that explanation was confirmed again in the pre-action response, see judgment 31. So the Secretary of State sets herself the test. Do these regulations create new powers or new offences of a criminal nature? first point in setting herself that test, she's already recognising that there is something acutely important about secondary legislation, indeed secondary legislation made by a Henry VIII power, which is conferring new police powers or creating new criminal offences. And she then finds that test isn't satisfied, so she doesn't need to consult more broadly. But we endorse the Divisional Court's reasoning here, that reasoning is to place form above substance. And I think that argument particularly lends itself to a Wednesbury rationality style argument, as well as fairness, because having set oneself the test of new powers or criminal offences, in my submission, it's irrational to then go on and conclude that lowering the threshold for police intervention with an intention that more protest activity is curbed means that test isn't met in the facts. Paragraph 1832 was the engagement of fundamental rights and the importance of those rights to democracy. Again, we have the point that the intention was that these powers would be used in a way which would interfere with otherwise lawful protest activity. Entirely right for the Divisional Court to see that as part of the factual context and to say this is distinguished from those sorts of cases where secondary legislation is being made to do quite technical things. Paragraph 183, Roman numeral 3, the idea of a readily... No, only the next two. I'm only focusing on the positive points rather than the defensive points, so I'm very nearly done. The readily identifiable class. So James's point here was, well, one looks at the economic note and there's a great long list of people that might be impacted. But the focus is who will be adversely impacted. And there, of course, the focus is very much upon protesters, and that's where one gets all of the analysis of how many prosecutions are going to follow, how many custodial sentences, and so on. The Divisional Court was right to find that there are readily available and well-known organisations, such as Liberty, who sort of sit above what we might call interest groups and are very much focused upon the value of democracy, the value of protest to democracy. See the witness statement of June Pang, filed on behalf of Liberty, supplemental appeal bundle tab 11, where she traces Liberty's history. And then final point, which is the scope of the issues, para 1834. And the nub of the point here is the conclusion that the government had sought views on the fundamental points of principle, not narrow technical implementation points. And so we say, in truth, what the Divisional Court was doing is collecting together all of those contextual factors and saying a case which has these characteristics is a case which called out for some sort of additional balance. They made the point it didn't have to be everyone, but what was unfair, framing it in the negative, what was unfair is to consult no one at all on the other side of the fence. And so that's why we say in our submission, the Divisional Court's conclusion on what fairness required is entirely the right one. I'll just take a moment to double check behind me. My lord, that's all we had to say on the consultation ground.
Thank you. There's a
Polly, can I have the... Yes. It's wonky, Tom. It's all right. I'll take one picture of the number. I'm warned it's wonky. My lord, these submissions are going to be wonky as well. Because the reason that the PLP has intervened in this case and filed the extremely extensive evidence about the legislative process is because, surprise, surprise, the clue is in the name, because of the PLP point, namely that the proper approach to statutory construction of potentially widely formulated delegated legislative powers permitting amendment or replacement of primary legislation. And that reflects a topic of long-standing continued interest for those who instruct me. As we've explained in section A of our submissions, what emerges most clearly from Lord Newburger's speech in PLP is that the conferral of a Henry VIII power to amend primary legislation by secondary legislation triggers what is in effect the operation of the principle of legality.
Well, hang on, Mr. Dingemans, you are only submitting on a particular point.
I appreciate that, my lord, but the point I wish to make is that informs how
Very well.
how one
Put it on
approaches.
the warning note, but
I was
you want to start with generalities before having conditions, so yeah.
I do, because unlike Liberty, we see this case as very much starting with the phenomenon of the Henry VIII power. We think that's the beginning of the analysis in this case, for all the reasons of constitutional concern that are triggered by Henry VIII clauses. And the reason why they trigger the operation of the principle of legality, and therefore what you must be astute to inspect the relevant statutory instrument for when undertaking the exercise of vires, is they trigger a concern of the circumvention of the very debate with the very safeguards that should occur before Parliament by the means of the use. Of course you do, but that's the concern. That's the particular problem, and it's a operation of the principle of legality that is triggered not by showing the breach of any constitutional right or anything of that kind. That would be the approach if you're in Section 3 or if you're in common constitutional law rights. What PLP shows is that that is triggered merely by the fact of a widely textured power that authorises the occupation by statutory instrument of a field hitherto operated by Parliament. And that must be particularly so when the topic of debate is as contentious as how to regulate public protest. That then takes us to the relevant provisions. And here we say the critical thing to appreciate is that section 11 and 12, and by extension section 14.
I thought I made it clear that you were asking you and giving you permission to make oral submissions simply on section C of your writs.
I'm going to do that, my lord, but the point I'm trying to make, my lord, is when you're construing the particular power in section 12.12, you have to look at the relevant concepts it draws on. The relevant concept drawn on in section 12.12 is a definition or provision of meaning to two defined terms, one of which is lifted from section 12.1AA, and that's noise in the vicinity of an organisation. The second is but one of the constituent elements of section 12.1A, and that is the serious disruption in the life of the community. Those are the only topics identified for potential amendment through the statutory instrument. So the question is, using Sir James's language, what is the object provision or object concept or the tether here? His submissions were that the tether was simply the language of serious disruption. And our submission is that that is wrong. The relevant tether, the phrase repeatedly used in the context of the amendments, is the phrase serious disruption in the life of the community. It's a compound concept in which the notion of serious disruption is informed by who the disruption is to, at what scale, and in what locality. And the critical thing to appreciate about the new definition of community that is inserted by the regulations is that it affects a fundamental change in both scale and locale, because you move from language, the community, that seems to be directed at society as a whole. It may be society or a community on a national, regional, or local level, but nevertheless is some form of embracing concept of scale, to a concept which embraces simply any group of persons who are affected by the disruption. And the word group, as these courts have consistently found, simply means two or more people. So what you have when you combine, and this is a critical feature when you're exercising the test set out by Lord Neuberger, and asking yourself whether or not it's in the contemplation of the legislation, when you combine the changes made to the definition of serious disruption with the changes made to community, and you insert the relevant definitions of cumulative disruption and relative disruption, both of which equally use the term serious disruption in the life of community, what you're left with is a test that operates to provide a power to regulate protest by conditions where there is a more than minor hindrance to the carrying out of the day-to-day activities, including travel, for any group of persons, that's 2 or more people, whether in the locality or elsewhere. That level of disruption, that scale of disruption, can be triggered by the cumulation provisions that allow you to take into account other relevant disruption from other assemblies and other pre-existing relevant disruption. For instance, roadworks in the Strand when taking into account the effect of a march on the embankment. And what you therefore have is a massive cumulative lowering of the threshold for the test by the operation of the definition of serious disruption in conjunction with this new definition of community and in conjunction with the definitions given to relevant and cumulative disruption. And our simple submission is that when you look at those provisions, whether it is in isolation or in combination, that change to the language of the community is a critical factor in the massive expansion in the reach of these powers that either in itself justifies the conclusion that the regulations are ultra vires or justifies it in particular in combination with the other changes made. Now, I do make the primary case that if the language of serious disruption and the move to more than minor was itself unobjectionable, it would be still objectionable to change the language of the community to any group of persons, because it removes any consideration of scale, any consideration of community effect, and simply creates a relatively adventitious test as to whether or not 2 or more people are affected by the physical consequences of the obstruction. There need be no unifying feature amongst the 2 persons. They needn't be in the same congregation, going to the same church. They needn't be affected by the same travel problems. All you need is 2 or more persons to trigger the operation of this test. But it is particularly clearly so when you combine it with the lowering of the threshold, because a threshold that is so lowered in terms of conduct that then is combined with a threshold that is so lowered in terms of scale and locale is, I would suggest, in many circumstances, a trivial hurdle to pass. And once it becomes a trivial hurdle to pass, the scope of the regulating powers, discretionary powers under section 12.1, becomes correspondingly enlarged, indeed enormous. It's difficult to think of many marches or any marches of any substantial scale that wouldn't trigger the operation of these powers. And that is not the precept on which this legislation was passed, whether in 1986 or indeed as amended by Parliament in 2022. And I do say, when considering these issues of scale, it is relevant to go back into the other things that are in the list in section 12.1, because what you'll see is that the way that section 12.1 operates is that you have the core original conception of serious disorder, serious damage to property, serious disruption. You have the original conception of intimidation of potentially 1 person. That is telling in itself, because it's clear that once you're dealing with intimidation and of just 1 person, it can't fit within 12.1a. And then you have 2 new definitions inserted in AA and AB, both of which also address the problem of scale, because they're addressing either, in the case of AA, noise that affects only an organisation, and that's patently been chosen because it's thought not to fall within 12.1a. In other words, it's telling you about the reach in terms of scale of 12.1a. And you've got 12.1ab, which is telling you something about the quality of noise, and that tells you how far you can go in adjusting the concept of serious disturbance, etc., in terms of the conduct in question. So the exercise of construction for the purposes of vires is informed by the contents of 12.1a through to b, all four limbs, and they tell you in very clear terms that effectively A is intended to be for problems of scale, and that tells you therefore that the attempt to reduce any consideration of scale beyond single person versus two persons is unlawful, and that is, in my submission, more than enough by way of textual pointers in the context of this legislation to trigger the operation of the presumption in PLP, and once that presumption is triggered, Sir James is dead in the water. Unless I can assist further, those are my submissions.
My lord, I just wanted to jump. I'll be very quick, Sir James. My lord, there was a question earlier about explanatory memorandums.
Yes.
And I have some instructions on that. There's a distinction, as I'm told, between corrections and substantive changes. The changes between the draft and the final version here were relatively substantive. There were new paragraphs 6.7, 6.8 and 10.1. When changes are more than just corrections, both the draft and the final version need to be published, and the Statutory Instrument Select Committee needs to be informed. But I'm told it's not that unusual for explanatory memorandums to be corrected.
It's a little bit too much to digest. It's peripheral. That's my fault for raising it at all. Having done that much, would you, I think for our general education, in case we want to say anything, but it is a slightly unusual feature, would you be able, with the benefit of those behind you, just to do a short
Of course.
one-page note about the precise status of trying to figure out how they work in practice as a matter of parliamentary procedure, not about the extent to which it's relevant for us to look at. And particularly on this point about different versions at different stages of the process.
Yes, of course.
Thank you very much.
I'm going to start with vires, and I have Mr. Bunting's submissions. And I'm going to focus first of all on the second part of his submissions, simply because those were the parts of the submissions that centred in on sub 12 and sub 13. And that might be thought the critical bit, because those are the enabling provisions. Mr. Bunting accepts that it is perfectly possible for serious to mean more than minor, and that is so in the very context under consideration, namely public order and processions and all things associated. He had to accept that because it is self-evident from the fact, I put it no higher than this, that it was used, that's more than minor as a concept, was used in the 2023 Act. I'll come back to that Act in due course. But he had to accept that important fact. But once he accepts that, he's got a difficulty. More than minor becomes one of the concepts that at least could be used in this context. It is a possible meaning for the drafter of a secondary legislative provision to draw on. And that is not a promising start, we submit, for a case that its use in regulations falls outside an enabling power that specifically and clearly permits regulations to be made about the meaning of serious disruption. His case is that the words about the meaning only permit clarification and not change of meaning. And we say in answer to that, first of all, they do not say so, and it's pretty remarkable that they do not say so if that was truly the parliamentary intention when producing those words, because it wouldn't have been beyond the OPC to have given effect to that in very clear terms. Instead, the wording actually used about the meaning
positively enables all aspects about the meaning to be dealt with. And to make that assurance doubly sure, the draftsman has gone on in sub 13 to make it clear that that wording includes both definition, and thus redefinition, and treating things as falling in and out of the object concept. And that involves shaping and setting the meaning of the concept. The second point perhaps to note is that Mr. Bunting's argument does not appear to mind terribly much changes of a particular type. He doesn't mind changes to tighten or to make the concept less onerous. So it's not about pure change versus pure clarification anyway. I don't make that as a semantic point. It highlights a deeper concern. Language may be open to arguments about whether you make a change that is up or down on that scale, as it were. So the intention has to be about the meaning wording with no carve out, and has in fact, the argument has to be that it has in fact got a carve out implicitly within it along the lines of, but only if that doesn't lighten seriousness. So that has to be the argument, apparently. But even that will not do. It has to be that the words do not lighten seriousness below some level, and that more than minor is below that level. But there is some level inherent in the argument. And the difficulty, of course, that all of those considerations go to is that the more convoluted, the more complex, the more difficult the structured intention which is sought to be imputed to Parliament through my learned friend's reading, the more difficult it is to reach the conclusion that Parliament could possibly have used the words that it did and then the concepts in sub 13 that it did. And my learned friend sought to give some answers to mitigate the problem that his relatively complex meaning gave rise to. His answer, first of all, was to assert the significance of the word "the." He says the really important thing is the reference to the meaning. In other words, he says that serious disruption has a single meaning, which is immutable but can be clarified and not changed. That, I respectfully submit, is untenable as an argument. It's untenable because it's untenable as a meaning to ascribe in context to the word "the." That word simply introduces the noun about the meaning. It would not make grammatical sense without it. It does not imply that there is a single meaning which is immutable. There evidently isn't a single meaning which is immutable. There are evidently different ways in which the concept in question, serious disruption, can be described and defined. That is the very thing which Parliament has enabled the Secretary of State to make judgments about, subject to its control. But even if there had been a single meaning, and that was what "the" referred to, that would not imply or even remotely suggest that the words in question make provision about the meaning indicated clarification, not change. They simply wouldn't have used the wording that they used if that had been the intention. The second point, which is related, that my learned friend sought to make, was related to the reference to definition in sub 13. It's even less convincing to seek to explain away the references to definition in sub 13 in this way. My learned friend sought to suggest that it implies, the reference to definition there implies one definition, and it's different if you're changing the definition. That was how he put it, but that also is very difficult. If you're using the word to define or definition, that must cover definition and redefinition. The power includes the power, as we know, to use new definitional concepts across the range. The language of sub 13 is defining any aspect of, as you will recall, serious disruption to the life of the community. And indeed, in sub 13, to treat things as falling within and without. And they therefore will, almost by definition, effect changes. And again, it's entirely unclear on my learned friend's case what his case is as to what would be an acceptable definition or treatment and what would not. The punchline again is, if you're going to come up with limits that you say are inherent on the actual concepts that Parliament has used, the more complex those limits that are said to be inherent are, the less likely it is that Parliament would not have made them very clear and specific. Instead of which, what they have done is to come up with the clear and unambiguous overarching permitting words about the meaning in 12, and then made absolutely clear that everyone understands that that includes both defining and treating concepts as falling within and without. So the third thing my learned friend Mr. Bunting then says is, well, we can see that in 2 capital A to 2 capital C, Parliament in 2022 was merely giving, as he put it, illustrative examples, and wasn't, as he put it, changing the base concept. But my submission is that that goes nowhere. 2 capital A introduced specific instances where, by way of particular examples, it would be serious disruption, and it used the adjectives and adverbs that it did. And it is that which can be changed in the ways just mentioned, by definition or redefinition, and by treating things in a different way so that some fall within and some fall without. You cannot say that that shows, therefore, that 2A was treated as creating some form of immutable intention to keep the object concept, serious disruption, high, as my learned friend kept putting it, without defining what that meant. And that is because, on any view, the enabling provision enables that provision to be changed. That's its purpose. There's nothing to suggest, for example, and he drifted towards this and then drifted back again, that the wording that said you can change this, there's nothing to suggest that that was introduced because 2 capital A had within it technical terms that might need to be clarified. There's nothing technical about any of the terms used in 2 capital A. And in any event, the purpose seemed to be that you could not change the adjective significant that was used in 2 capital A before the word delay, and there's nothing remotely technical about that. So that doesn't advance the argument that he was making. Can I turn then to his submissions that there is a meaning of serious disruption, and that in some way informs the meaning of the enabling provision? He put that first in the structure of the argument, as you recall. I take it second to make some short points in relation to that. The premise for the argument is that serious disruption had a high meaning, it was said, which it retained in 2022. So the enabling power must have been intended to permit clarification, not change. That was the nature of the argument. And my answer to that, you will appreciate, is one, that focus starts in the wrong place. The words to be focused on are those of the enabling power, and they enable the provision to be made so long only as it is about the meaning of that concept. 2, I do not accept that the search should be for the meaning of about the meaning is even informed by looking for the interpretation that the court would or might have arrived at in 1986 or immediately prior to the changes in 2022. And I went through all of the reasons for that in opening, and I don't repeat them. Thirdly, and in any event, there is, again, as I pointed out in my opening submissions, or perhaps as the court pointed out to me, there is no case law or other judicial guidance to support the proposition that in that context, serious disruption could not use the concept of more than minor as one of the linguistic tools on which to draw. All agreed that all the other context of all the other case law that has been referred to are other contexts and therefore don't go anywhere. Fourthly, there is nothing in the point that my learned friend made repeatedly that these provisions are to be treated as criminal provisions. In this context, that point appeared to be used to suggest that it supported a high interpretation of serious disruption, in my learned friend's language. And my submission is it does not even do that. All of these provisions, i.e. the ones we're actually focusing on, are about the nature of and preconditions to the direction-making power of the senior police officer. You're aware how well aware of how section 12.1 is structured. That's what these provisions go to. Those conditions would have to be lawful if they were to be imposed in any case. They would have to be lawful both in satisfying the legislative preconditions to the exercise of that power and in ECHR terms, because all that's being conferred is a power on the senior police officer subject to those preconditions. So they'd have to be lawful in ECHR terms. It's a power that will be exercised by the police. So the assumption thereafter is that unless successfully challenged in a judicial review, that is, unless the exercise of power by the police is challenged successfully in a JR, either because it said the preconditions aren't satisfied or because it's ECHR incompatible, the exercise of the power has to be assumed to be lawful in both senses, including, therefore, in its balancing, in the exercise in every case, of the rights and interests of those involved.
Would it be a defence in criminal proceedings, absent express reason to choose there is to say the direction you were going was unlawful as a matter of public law and
My lord, I think the answer to that is yes, it is. Yes, it would be. It's Bonington, but you'd have to. I mean, my argument proceeds at an earlier stage, which is that even before the condition is imposed, there would be a requirement for HRA lawfulness in the exercise of that power. Yeah, but I think the answer to my lord's question is yes, sure. Yes, but you see the punchline of where I'm going. You can balance at either or both of those stages the rights and interests that he kept saying you couldn't balance. You can balance them. And the second punchline is that it is only if that lawfully exercised set of conditions is breached or ignored that crime is committed.
Yeah.
The criminality is separate from the power in that real and very important sense. And that undermines entirely any reliance on criminality to suggest a high meaning. And the same answers can be given to the common law rights point. It's exactly the same. You can balance them at either or both of those two stages, and it would have to be lawful in striking the right balance for the exercise of power itself to be lawful. Then my learned friend turned to section 34 of the 2023 Act. And you have the basic point that it makes clear that serious disruption in a context such as this can mean more than minor. That's a perfectly possible meaning in concept, as my learned friend accepted, in context as he accepted. That doesn't depend on impari materia or anything of that kind, but if impari materia did become important, we maintain the position that it is impari materia for all the reasons I've given in the skeleton and in opening. My learned friend's points were firstly that it was Parliament itself that was doing this in 2023. You'll remember that way of which my learned friend presented the argument. And of course he's right, it is in primary in 2023. There's no one's denying that. It's in primary and the regulations are in secondary. But that does not, I respectfully submit, meet the force or sting of the point that demonstrates that in the same context, the public order context, that serious disruption has been taken by Parliament itself to mean more than minor. Just simply points to the fact that that was done in primary legislation, so be it. And that leads to the second point, which I think my learned friend's submissions implicitly recognises. That's why he seeks to suggest, and has to go on to seek to suggest, that the 2023 Act does use the more than minor concept for good and legislatively coherent reasons, and he sought to address that. But those reasons is my first point of answer on that. Those reasons have to be for that purpose, or they have to relate to the use of more than minor in the definition of serious disruption in 2023, but not in the context of the creation of the power, processions and conditions and so on in the 2022 Act. The offences in the 2023 Act are of course different, and they do include reasonable excuses defences, and that would no doubt enable one to weigh all the factors there in the way that you can't in the context of the 2022 Act, was the argument. But that simply can't work. It's impossible to see why that would explain the decision to have a lighter degree of disruption in the 2023 Act. You would expect, naturally, the same degree of disruption to others across the piece, particularly given that you can balance in both. But it's based on a miscomparison. The serious disruption in the context of the 2022 Act is used, as I indicate, to set the threshold to the exercise of power by a senior police officer to give the directions. It's not an offence at all at that stage. You're not comparing offence with offence. You're comparing offence with the creation of preconditions to the exercise of a power. And that's a non-comparison. But moreover, the assertion of a reasonable excuse defence enables the submission that it enables the interest to be balanced in 2023 Act but not in 2022 Act is wrong for all the reasons I've just given. You can balance them in the 2022 Act, and police would have to in order lawfully to exercise the power that is given to them. The offence in the 2022 Act, moreover, is created only if you break lawfully imposed conditions. That is the offence. And if anything, it might be thought, you would expect the direct offence of tunnelling to require a higher level of disruption rather than the other way around. Finally, he suggested that the lower standard in the 2023 Act was explicable because the offences in that Act were more serious. My first answer is, if they were more serious, one would expect a higher, not a lower standard. So my learned friend had to say, yes, but there is a greater public interest in protecting against the offences being committed. But that can't help. The seriousness of the offence would naturally lead to more stringent ingredients. It also cannot be right in characterisation of more or less serious comparison. The offences in the 2022 Act are for not complying with a lawfully imposed condition, which is a pretty serious matter in its own right, because you know what you have to do and you then do not do it. I come briefly then to the Henry VIII clauses.
Yes, I see, Nancy, Clark, you can run over by a few minutes before you.
I'm very grateful. I'll try not to do more than 5.
You're off at 1, but I think I can't do much later.
Thank you. The Henry VIII clauses points, I gave you, and I deliberately gave you, the latest Supreme Court word on the actual principle that is in play in Henry VIII clause context. And that is paragraph 109 of the unanimous Supreme Court's judgment in Re Alistairs. Tab 43, page 1118. And I also gave you Mr. Justice Linden and Kellogg at paragraph 80. I hope I can't be accused of deliberately ignoring PLP. PLP is referred to in Kellogg, and PLP will have been well known to the Supreme Court in Alistairs. My submission is that there's nothing in PLP which is remotely inconsistent with the pithy summary at paragraph 109 of Alistairs, and indeed they're exactly to the same effect. What the PLP judgment indicates, as you will see when you go back to it, if you go back to it, is that there's a section leading up to the end of paragraph 22 where they consider in effect whether you can challenge secondary legislation even though it's been subject to affirmative resolution procedure. And the answer to that question is plainly yes, you can, because they are made by the executive. They then go through the relevant McKiernan and all that line of authority, and they reach exactly the same place that you see reached at paragraph 109. I do not accept that the Supreme Court was, as it were, varying away from the suggested approach in principle to how you would go about approaching a Henry VIII clause. In other words, you look for the natural ordinary meaning of the words, and it's only if there is genuine doubt about that meaning that you then have resort to the principle that you see expressed at 109 of Alistairs. PLP thereafter turns on the particular facts, the particular statutory provision or provisions that the court was considering there, and doesn't add much, if anything, beyond that. And the same point can be made in relation to RBAB, tab 46, which was referred to briefly. the only point I want to make about that is if you do go back to that, it doesn't add anything to the sum of human knowledge in terms of the approach in principle, didn't seek to. So nothing to be seen there. On its facts, it removed the possibility of an appeal altogether, so it was truly a controversial context because it involved, in effect, unison style shutting down of access to court. So unsurprising, perhaps, that the court took a pretty dim view of that. Finally, on vires 119A, the new statutory provision, my short submission in relation to 119A10 is that if anything that supports me rather than my learned friend, because what it acknowledges by reference to the word including in the bracketed section is that changing the meaning is something which is already included within a provision about the meaning, making provision about the meaning of the object concept. So it's positively acknowledging that changing the meaning would naturally fall within that and is making absolutely clear so there's no misunderstanding that changing falls within that. Otherwise, the provision would have been structured differently. It would have said the Secretary of State may by regulations make provision about and changing the meaning of. So we respectfully submit that that reference to including provision changing the meaning is positively supportive of our No, I don't think so.
I think that, to be fair to Sir James, this was introduced in 2023, so that is introduced after the statutory provision in our case, but I don't think it was introduced after the Divisional Court's judgment in this case. So that's the chronology of it.
Well, I'm grateful, but
it's not insignificant.
no, but the short point anyway is that on the meaning of it, it's including provision changing the meaning, and including provision changing the meaning suggests that that provision is included in the base concept, which is provision about the meaning of. Otherwise, as I say, it would have been drafted differently. It doesn't say make provision about and changing. So that's what we say about 119A. Community, my learned friend Mr. de la Mare's submissions, I've got nothing further to add. We rely on what we said in the skeleton. Consultation, voluntary consultation, I'm going to focus on, if I may, on the facts on voluntary consultation. The focus of my learned friend Miss Higgins was on the Q&A document that was at tab 24, page 148. You'll recall that. I should take it up again. I simply invite you to note that there was within that document, and this is really the limit of it, there was within that document only one question, a single question that related in some peripheral way or incidental way to the more than minor issue. Only one, and that I think was the fourth one. That tells you the scope and nature of it. But even if you look more broadly at that document, the point that I maintain is that it relates to and was designed to elicit the operational expertise and views, both past perspective and future perspective, of the police, and that's what they gave. On the relevance of the word consultation, my short answer to the submissions my learned friend sought to make, which was not really relevant much, but could possibly be, is that it has no relevance that you use that word or you don't use that word, and I haven't sought to be careful in my submissions on that. But Lady Justice Leng, I respectfully submit, was right at paragraph 81, where she described it as legally irrelevant. I respectfully submit that is right. That was the position. The broad point on the facts I wanted to make was that when one has gone through all of the documents that you've seen that constituted the consultation, and it perhaps goes to a point that my Lord Justice Dingemans was putting to me about the nature of the test that you apply, although of course in principle this was an evaluative exercise by the Divisional Court, the fact of the matter is that there isn't really and wasn't really any dispute at all about the base facts. The facts on which both parties relied were drawn from probably one or two documents of any real significance. That's it. And you're just as well placed to make a judgment about such facts as may be relevant to voluntary consultation. What we're really arguing about is the the legal implications of those facts. So far as Evely is concerned, my learned friend's case basically was that the Court of Appeal was, as she put it, trying to articulate the touchstone test. And I simply don't accept that characterisation of what the Court of Appeal was doing. Certainly they were setting the preconditions without which there could not be voluntary consultation, but there's nothing to indicate that they were seeking to suggest that their analysis on that front was designed to cover the field so that if only you met them, then everything else that would follow would be voluntary consultation. And it's entirely unsurprising, not merely is that a proper construction or even a tenable construction of the judgment as a whole, but it would be very, very surprising if it were otherwise because of the consequences that would entail. We know that the three basic conditions that they were looking at, and if one puts them, I'm going to come to my Lord Justice Dingemans' circularity point in a second, but if you put Lady Justice Leng's three things on that side and then the gunning criteria on the other, you'll see the correlation, as it were. But the three things that the Court of Appeal were focusing on, encapsulated in Lord Justice Bean's paragraph 95, were specific decision contemplated which might adversely affect a person or group, or defined group as it was put. 1, 2, sufficiently formative stage. 3, crystallised sufficiently as a possible contemplated decision so that you could actually explain enough about it. But those three things, if taken in combination, would apply pretty much to all government policy. All government policy would end up in that place, and that would effectively mean that you voluntarily consult if you consult any public authority whenever that happens. So if you talk to anyone, any public authority after that, or if those three are satisfied, it's voluntary consultation. And a number of things flow from that. Firstly, it prompts the question, on my learned friend's case, was Appellant wrongly decided? And if not, why not? And there's no suggestion in the Court of Appeal in Evely that anyone even remotely thought that. And the second point to which it gives rise is that my learned friend was ultimately forced into not shying away from, as it were, sort of lethal language in the submission that that hers was a very broad, as she put it, consultation conception, and that the way of dealing with that was not to narrow the concept of voluntary consultation, but was to deal with it at the fairness stage. My submission is that that does not meet the point, that voluntary consultation and targeted engagement, a distinction well recognised in the case law, would effectively collapse. And it does not meet the base governmental point. One of the things that both Lord Justice Elias and the court in Bappia were very concerned about, the impact on proper and good government. It doesn't meet the argument that comes back at her immediately, which is that it's too high a price to pay. On her argument, the virtue of clarity through her very broad conception of consultation is, I respectfully submit, undermined by its achievement only at the expense of covering, in effect, the entire universe of government policy. And that is not answered by saying, well, there are some cases which would be left still outside the reservation, including, for example, cases in which a decision in principle has been made. That would still leave vast numbers of decision-making where, in effect, the government would be confronted with a very strange choice. Make a decision in principle before you go about talking to the relevant public authority that has been involved in the administration of that part of government or would be in the future. That's a very strange, incentivised place to get to, I respectfully submit. I come very briefly to my Lord Justice Dingemans' circularity point. My submission is that the reasoning in Evely is not circular. What Lady Justice Leng was very concerned to explain was that she was only looking at the gunning criteria for the purpose of trying to work out what stage a more or less inchoate set of thinking or proposals are needed to get to before they could properly be characterised as voluntary consultation. And so she was using the gunning criteria to inform that exercise. And if one looks at the gunning criteria, I put Lady Justice Lang's 3 on the left-hand side of the page. On the right-hand side of the page are the 4 gunning criteria you saw from, I think it was paragraph 26 or 25 of Mosley. They're 1, still at a formative stage. 2, give sufficient reasons to enable intelligent response. That perhaps is the key one for present purposes. 3, adequate time for response, drifts away. 4, take into account, again, drifts away. So what Lady Justice Lang was saying is, you look at the gunning criteria in order to get to a sufficient level of movement away from an inchoate nature for contemplated decisions. You have to get to a stage where it's, as it were, sufficiently targeted, sufficiently detailed in its thinking, but still at a formative stage to enable you to go out to satisfy those criteria. That's the species of reasoning, and therefore I respectfully submit in her defence, as it were, that that isn't a circular way of reasoning. No.
It was the analysis and just asking to deal with witnessing to deal with that, whether it was circular.
Whether it was circular. No, my lord, I'm sorry, I wasn't intending to impute. But anyway, our positive submission is it isn't. She was using it for that purpose. Then finally, on fairness versus rationality, I've made most of the submissions I wanted to make in opening. None of the cases my learned friend took you to truly advance the submissions. The early setting the theme, haberdashers type authorities don't go anywhere to support her, not least because most of them were about completely different things. Like procedural fairness in a professional disciplinary complaint process. That's got really nothing to do with the consultation context at all. I've made my submissions in opening about the position and nature of the arguments in the Milton Keynes case and what the Article 39 case involved. As you know, my case on fairness versus rationality is if you voluntarily consulted, A, that doesn't require you to voluntarily consult B as a matter of fairness, rationality, or anything else. But the true analogue at that stage, when confronting the question who else would one have to go to, the true analogue at that stage is Thameside. And that's a fundamentally rationality-based thing. And in part the reason for that is because you can't be compelled, just because you've consulted A, to go to B on a comparative basis, because it would be a bit unfair otherwise, because that got blown up in Gallagher as an idea, where you have no common law right, as it were, to equality of treatment in that sense. So those are the submissions we make on fairness and irrationality, and I've nothing to add to the third limb, which is the 183 point. Well, I'm grateful for the extra time.
Well, we're grateful to all council and those behind. Very high quality of submissions received orally. We will, of course, be reserving our judgment. Our judgments, they will be circulated in draft in the usual way and subject to the type constraints set out in the council government way case, which I'm not proposed to probably do a summary of, but these restrictions are indeed taken very seriously. Thank you very much.